Just one more sec. Okay, go ahead.
Okay, thank you. We'll just start over here. So this is case CR 22-21-1623, State versus Chad Guy Daybell. This is the time we have scheduled on a hearing on defendant's motion to extend time for motions to be filed and heard under Idaho Criminal Rule 12B. The motion was filed on December 9th. Mr. Pryor represents the defendant. Mr. Wood will be representing the state for purposes of today's hearing. We are conducting this hearing remotely on Zoom. It's being recorded on the FTR system of the courtroom as well as reported by the court reporter, and it's also being live streamed for public access on the court's official YouTube channel. The court has received and reviewed the motion. Mr. Pryor, in terms of the attendance of your client, he has a right to be here and attend this hearing today. Have you discussed that with him, and does he intend to appear?
Yes, Judge, I discussed that with him yesterday, and he has elected not to appear today.
All right, well, where this is a purely legal argument under the rules, I'll excuse his attendance for this hearing today. I have received and reviewed the motion, which is a second renewed motion to extend time for filing a 12B motion by the defense. There has not been any objection filed by the state to the motion. Mr. Wood, does the state have an objection to the motion?
Yes, we do, Your Honor.
Okay. All right. I'll note that the arraignment in this case occurred on June 9th of 2021. There's been some fairly extensive delays because of preparation and obtaining of grand jury transcripts, and I know that was cited in your motion, Mr. Pryor, but at this time I will hear argument on your motion to extend, so you can present your argument.
Judge, if you, in a review of the record, you will note that on 6/21 of 22, I filed my first motion to extend time. That was granted. Then on 9/21/22, still not having possession of the grand jury transcript, I filed another motion to extend time. Once I received the transcript, and my recollection is I received that sometime in the mid to late of October, I then had the 5 days of grand jury, and I'm not going to discuss the particulars of what's in the grand jury, but it was a significant grand jury transcript. I would say that, Judge, this was the longest grand jury transcript I have ever encountered. Part of the process of having to go through this was, one, having to read the grand jury transcript. Then I had to go back, Judge, and I had to review the preliminary hearing transcript of what each and every one of the witnesses talked about in front of the preliminary hearing in the original case. Then I've had to go back and compare the preliminary hearing transcript with the grand jury transcript and each and every one of the witnesses that offered evidence to the state that, at least to this date, has been provided to me. Judge, I will tell you that was a onerous task, and at this point, I just got, with stipulation of the state, to get the voting record. And I did manage yesterday when I was in Fremont County to take a look at the voting record. I felt that after the court did the initial trial setting, and I believe that was on 12/3, that under my reading of the rules is that I needed to file a renewed motion, a second renewed motion to extend time to be able to preserve that. Now, in reading of the rules, when the trial setting was set, at least my reading of the rules is that there was an opportunity within a short period of time, 28 days, to file a motion to dismiss. I don't think that was sufficient enough given the incredible length this motion is going to encompass. It's a significant amount of information in this, what's going to be addressing this grand jury proceeding. There are a number of issues that I'll need to bring up and a number of issues that I'll need to address. And Judge, it's not just something as simple as filing a motion to dismiss and saying this is what I have a problem with. This is 5 days of grand jury testimony. The standard, Judge, is excusable neglect, but there hasn't been any neglect here. What there has been, I've been diligent in going through all of this information, reviewing all of this, and quite frankly, Judge, the magnitude of the work is going to require that I'll need some additional time to do that.
And Mr. Pryor, I'll just note the rule allows for extension for either good cause shown or excusable neglect. So
Right.
that option's available under the rule as
Right.
well.
And Judge, what I'm asking for is good cause. And frankly, Judge, I don't have any information, but I did contact Mr. Archibald, who represents Ms. Vallow, and I discussed with him, I believe in late December, that, oh, I'd strike that, I think late January, late December, I'm in December, that I had heard that there was another grand jury proceeding with additional evidence that was presented to the grand jury. I contacted Mr. Archibald. I was advised that Mr. Archibald had heard the same thing. I anticipate, Judge, asking for a transcript of that grand jury proceeding if in fact there was one. I don't expect Mr. Wood to address that or even acknowledge that. He doesn't have to. It's something that if he chooses not to acknowledge that it occurred, I'll petition the court for whether or not that there was a proceeding. But I did hear as part of the investigation that there was an additional grand jury proceeding conducted. So at that point, if there is, Judge, and there was any testimony as it relates to this case, at that point, I'm entitled to that information, additional information, and if there were witnesses and testimony, I should be afforded a chance to get that information prior to me even filing any kind of addressing any concerns I might have in the grand jury transcript. And with that, Judge, I'll hand this over to Mr. Wood.
All right, thank you, Mr. Pryor. Mr. Wood, state's response.
Thank you, Your Honor. I would note that in the defendant's motion, the reason for his request in the motion is simply that there was another grand jury proceeding. The state has no problem acknowledging there was a grand jury proceeding. The state does disagree that it affects this proceeding in any way. I would just note for background, Idaho Criminal Rule 12B provides that a defendant can file a motion to dismiss for defects in an indictment. There are time limits on that. Those time limits are provided by Rule 12D. And we've talked about already, it's 28 days after a plea of not guilty. The state in this case did not object to Mr. Pryor's first two motions. As has already been stated, the grand jury transcript was not prepared. That's certainly good cause for an extension of time. However, the state would further note that those timelines do exist, and failure to exercise those rights in a timely manner does constitute a waiver of such right. That's found in Rule 12F, and case law affirms that. I note State versus Jones 140 Idaho 755 states that tardily raised objections based on defects in an indictment or information are waived unless they allege either a failure to show jurisdiction or failure to charge an offense. The defects for which an indictment may be dismissed are found in Idaho Criminal Rule 6.6, none of which were alleged in the defendant's motion, none of which have been alleged by the defendant today. In terms of the timeline of this case, I think we've already discussed that. I would note at this point, we are more than 90 days out since the defendant received the transcript. He has not filed any 12B motions to date based on that transcript. I would note he talked about the voting sheet. The defendant has only recently asked for that voting sheet, more than 2 months after he received the transcript. Now, we certainly, we did stipulate to him being able to see the voting sheet because the rules say he's allowed to. But if he wanted to base any type of motion, 12B motion on what's contained in that voting sheet or the transcript, he should have acted on that a lot sooner. He could have asked for that at the same time he made a motion to receive the transcript or when he received the transcript. Instead, he waited well past 28 days after the time he received the transcript to even make that request. Again, I would note the defendant has not alleged any defects whatsoever in the transcript or the indictment under which the defendant was charged. He hasn't presented any good cause other than it's voluminous. Well, he also alleged in his motion that he has read the entire thing. We understand there's a lot of work. Having said that, he hasn't done any of the motion work necessary to file any, to prepare for a 12B motion. In terms of this additional grand jury proceeding, he's never filed a request for that transcript. Now, the state actually believes he's not entitled to that under Rule 6.2C, which dictates who's entitled to a grand jury transcript. And I'm only noting this, Your Honor, because this is the reason listed in the defendant's motion. Grand jury transcript is limited to the prosecuting attorney, any individual indicted by that grand jury, or anyone charged with perjury due to their testimony in front of the grand jury. Mr. Daybell does not meet any of those criteria. Mr. Pryor is correct that grand jury proceedings are extremely confidential. The state does feel comfortable saying that his client wasn't even the subject of the grand jury proceeding that day. The only way that additional grand jury proceedings could reasonably be used to attack the initial indictment is if new charges were brought against the defendant and the state attempted to merge or combine those two indictments, which hasn't happened. Again, I've already brought up, he hasn't even filed a motion for that transcript. He only recently asked for the voting sheet. The right to file a 12B motion to dismiss an indictment for defects in the indictment protects the defendant's right to fair proceedings and a fair trial. However, the defendant's not the only person entitled to fair proceedings and a fair trial. The people of the state of Idaho, specifically the people of Fremont County and Madison County, are also entitled to a fair trial. The victims in this case are entitled to fair proceedings and fair trial. It would be unduly prejudicial for the state to grant the defendant, or for the court to grant the defendant's motion, where he's clearly waived as 12B, or his rights to file under 12B. We're more than 90 days out from the time he received the transcript. At some point, Your Honor, the problem is we're well into trial prep. We're getting ready for trial. Timelines are provided by the rules for these things to be taken care of in a timely manner. If Mr. Pryor had filed those other motions, we might have a different position, but he hasn't. They've made the tactical decision to not file any of these other motions. He has raised no allegations whatsoever of defects to date. And so in conclusion, he's failed to state any reason or good cause why any additional proceedings in which the defendant was not indicted should be subject grounds for an extension of time. He's provided no good cause in terms of actions he's taken to preserve those 12B motions. The defendant has not provided the court any excusable neglect for his decision not to do so. As such, as a matter of law, he has waived his right to file any 12B motions, other than those regarding jurisdiction or failure to charge an offense. So the state respectfully requests an order denying the defendant's motion, in which states the time to file any such motions is now expired. Thank you.
All right,
If I
thanks for
could
the
briefly
argument,
respond,
Mr. Wood. I'm going to allow what did you say, Mr. Pryor?
May I respond, Judge?
Yeah, I was absolutely going to let you respond. You just didn't give me a chance. So
Okay, I apologize.
Thanks for the argument. Mr. Pryor, what's your response?
Judge, I would point out that I filed a timely motion to extend time on 6/21/22. I filed another one on 9/21/22 because I had not had the transcript at that time. My recollection is that there was never a formal order extending the time, although I think on the record the court extended the time. At that point, I had not had an opportunity to review the voluminous nature of what was transpired here in terms of 5 days of grand jury testimony. So at that point, after he was provided the initial district court arraignment on 12/3, I filed another extension of time. I can't see logically how Mr. Wood can claim I wasn't diligent in seeking an extension of time because of the voluminous nature of this evidence when on 3 separate occasions, Judge, I filed motions to extend time. I take issue with Mr. Wood's suggestion that if witnesses were called during a grand jury transcript, and I want to thank Mr. Wood for acknowledging the grand jury. He didn't have to do that, and thank you for doing that, because there now will be a motion to get that transcript that of whatever was said to the grand jury. And Judge, if there were any witnesses who are witnesses in this case, now I would suggest that they probably called witnesses because they don't reconvene a grand jury and not put witnesses on the standard testimony. So anything that was said, the suggestion that I wouldn't be entitled to it, I think is ludicrous, because any information about what a witness says in front of any kind of a proceeding, I would be entitled to it. You don't get to cap this under some rule that says you don't get this. So if there now is grand jury testimony, Judge, I need that testimony. In addition, an opportunity to review that before I go forward with this motion. So I would respectfully ask the court to extend the time. I believe that the sheer nature of the volume in this case, and as an example, the court saw the voluminous nature of the venue information that I had to submit. I would represent to the court that that's only a fraction of what this case involves in terms of evidence. So given that, Judge, I think I've shown good cause, and I don't want to allege that there was excusable neglect, because there has been no neglect. I've been diligent in filing 3 motions to extend time, asking the court to give me an opportunity to adequately prepare this before. And Mr. Wood suggesting that I haven't alleged any problems with the grand jury proceedings. Well, Mr. Wood, that's not what a motion to extend is for. The motion to dismiss is to allege those things. And once the court provides me an opportunity and sets a deadline, if I deem that that motion to dismiss needs to come forward, it'll come forward. It'll allege what needs to be alleged. Thank you, Your Honor.
All right, thank you, Mr. Pryor. I've considered the arguments of counsel and the reasons stated in the motion. I've also considered Idaho Criminal Rule 12D, which goes through the time frame. I'd note that 12D reads that motions under Rule 12B must be filed within 28 days after the entry of a plea of not guilty or 7 days before trial, whichever is earlier. It goes on to state that in felony cases, motions under Rule 12B must be brought on for hearing within 14 days after filing or 48 hours before trial, whichever is earlier. And then importantly, it indicates the court may shorten or enlarge the time and for good cause shown or for excusable neglect may relieve a party of failure to comply with this rule. So going back earlier into the history of this case, there was an arraignment in the case that took place on June 9th, 2021, and a timely motion to extend was filed and granted by the court. There was an initial order on June 23rd where the court ordered an extension of the time and indicated that the motion was to be filed and heard by September 10th of 2021. And that was a time frame we discussed in relation to when we thought the transcripts would all be available to be a completed review to allow an adequate opportunity for the filing of a motion under 12B. As we learned later, then the transcripts were still not done at the time of that initial extension, which went out into September. And those transcripts, in fact, didn't get done, I believe, until October. There were intervening motions filed to preserve the request to extend under 12D. I don't find there's been a excusable neglect here, because I do agree with Mr. Pryor's analysis that he's preserved the issue. And so the question before the court is whether or not there's good cause shown in this filing today. And I do find, first of all, that the rule obviously builds in quite a bit of discretion. And I think the policy of the rule is to allow the parties adequate time to bring such a motion well before trial so that everybody doesn't complete trial preparation and then find out a case is dismissed on the eve of trial. And I think one of the important things the court considers then is when is the trial in this case. And that's an important factor to me because our trial is still a year away. We don't have trial scheduled until January of 2023 in this case. And so due to the voluminous nature of the transcripts, I do find that good cause is shown for an extension. However, now that those are completed, the court is going to order a specific time frame like we did in the first order back in June of last year and set the hearing as well as the deadline for the motion. I just want to discuss the setting of the hearing, of course, because the rule then gives a quick time frame for the hearing to be heard after the motion is filed. So I'd like to include in an order the deadline for both of those. All the discussion of any further grand jury proceedings is beyond the scope of this hearing and not anything I'm considering, and I'm not making any ruling based on whether or not there was any further grand jury proceedings. All I know is there was no further indictment. So to me, that does not factor into this decision at this time. So with that in mind, there is still quite a lot of time before trial, but it's also a motion that I think has been out there and you've known about it for a long time, Mr. Pryor. And as you've indicated, you do now have the completed transcripts and you've reviewed those. So I don't know that this needs to get extended any longer than possible, because I think the state is correct that it's entitled to know the answer to this question as it's preparing for trial, which it's already starting to do. So I will grant the motion, and I want to now discuss a deadline for having that hearing and filing of the motion. And I'll note my calendar's a little tricky for the next, between now and March, although I do have some dates where I can get a hearing scheduled. So what is your suggestion on a proposed time frame when you'd have this ready to be heard, Mr. Pryor?
Judge, the end of March, I'm unavailable the 24th and 25th. The 29th through the 1st, I'm available if the court has any time at that point. That would be, that should be sufficient if the court can fit it in at that point. I do note that we do have another hearing on this case that I believe is set for the 18th of March. Actually, two hearings, one at 9 and one at 11. So I don't know that we should have it before that time, but obviously I'll defer to the court's wisdom.
I think this motion is really independent of those other motions and could be heard prior to that. So I'm looking to see if we could fit this in. I definitely don't want to do it on the 18th with those other hearings. I'm not sure how long the motion to sever will take, but I think we need to reserve time for that. I'm just, if you'll give me a moment, I'm just reviewing my calendar and what dates I don't have available due to other trial settings. How about March 23rd?
I can do the 23rd of March, Judge, yes.
Your Honor, is that the hearing date?
Yeah, that's, and I appreciate you bringing that up, Mr. Wood. I'm kind of going backwards here, but I'd like to get the hearing date scheduled, and then in accordance with the rule, we'll set a motion filing deadline. How does that day look on your calendar, Mr. Wood?
That day works for the state. That's the state's preference would be that this issue be taken care of before any other motions, though. Where it would be a dispositive motion, at least a temporarily dispositive motion.
Judge, I don't anticipate that the court's going to make a decision from the bench either on the severance or the other motions on the 18th. And frankly, having the motion 2 business days after that, I frankly believe the court's going to need some time to ponder all of these. And I fully expect the court could probably prioritize and decide on the motion to dismiss before putting any effort into its formal decision on the other 2. So I don't have as much concern that they're close in time as the court's going to probably not rule from the bench on all of these.
All right. I've considered all of that. I do find that the 23rd is a date that works for the court, and also in terms of the order of the proceedings in the case as well. So we'll schedule the hearing on the motion to dismiss for March 23rd. And then under Rule 12D, Mr. Pryor, then that will set your deadline for the filing of a motion of March 9th.
Thank you, Your Honor.
So if you'd prepare an order, Mr. Pryor, that indicates March 9th is the filing deadline for the motion and the 23rd will be the scheduled hearing on the motion.
I will do that, Judge. And may I ask, Judge, I didn't hear what time on the 23rd?
Thanks. I believe I didn't mention that. So we'll just indicate that that will start at 9:30 a.m.
All right, Judge, I will get an order out and you should anticipate getting those motions shortly.
All right. Thanks for your participation in the hearing today, both. Is there anything else we need to bring up this morning on this case, Mr. Pryor?
No, Judge, may we be excused?
Yes, Mr. Wood, anything further?
Not at this time. Thank you, Your Honor.
Okay, thanks, counsel. We'll be in recess.